I'm a big fan of guided choice dispute resolution, which is particularly well suited for resolving design and construction disputes because it tends to promote the early settlement of claims. Everything that I know about guided choice dispute resolution, I owe to my former law partner at Schiff Hardin LLP and mentor, Paul Lurie, who is certainly the driving force behind guided choice dispute resolution. And there's a couple things that are pretty obvious that need to be considered when thinking about how to resolve design and construction disputes, and specifically, what is the most advantageous way to achieve our client's interests. And I think it's undebatable that most commercial design and construction disputes are simply not arbitrated or litigated to a binding outcome. In other words, they tend to be settled before you reach a jury trial or a bench trial, or before you have an evidentiary hearing before arbitrators who would pick a winner or a loser. And it's important that we pay attention to the obvious fact that preparing for trial or arbitration can be expensive, particularly in complex cases. But in this age of electronic discovery and electronic files, even simple cases can get very expensive to take to trial or a binding arbitration hearing. And one of the keys to bear in mind is that those costs grow in proportion to how long a dispute tends to survive, how long it's around before the parties are able to work out a settlement. And so I think that when we talk about mediation, including guided choice dispute resolution, I think that we could say that earlier settlements are better without the need for getting into some pejorative ideas about, oh, we're just going to have a mediator split the baby, or having some kind of a surrender to the other side in the interest of having a settlement. You know, it's certainly not the case that you need to give up your strategic interests in order to achieve a settlement. And there's certainly nothing inherent in saying that earlier settlements are better, which suggests that me or anybody else has some, blinding love of mediation. Certainly, it's no panacea. It has its advantages and disadvantages. And I think it's important, now that we've established that design and construction disputes almost always settle, but they settle too late, to ask ourselves, what is it about the process late in the game that tends to make these cases settle short of trial? And I think that these disputes tend to have certain unique facts, which, when those facts are identified, they eventually lead the parties to settle. And now identifying them would seem to be particularly important if that's the case. And if we want to identify those unique aspects of the dispute which tend to lead them to eventually settle, but settle too late, I think that there's a new and different approach that is required for each case. It's not one size fits all, and it's really the process that is going to be run during the time when the parties are actively trying to resolve the dispute, I think, which is where the magic is. And that's why I love guided choice dispute resolution. It is a customizable, process-driven, multi-phase form of early alternative dispute resolution. Done right, guided choice dispute resolution allows the parties to have greater control over their costs incurred and the outcomes of their disputes. And there's really very little that's needed. Any pre-mediation clause, any pre-dispute mediation clause, in other words, a design or construction contract that may have been signed years earlier, which says the parties are going to mediate, is sufficient to initiate a guided choice process. And then the only things which are missing, if you've got that mediation clause, is the advocate's commitment to insist on running a guided choice process, and critically, being able to locate a mediator that understands and is willing to run a guided choice process. Now, I can tell you that when I have my most concerning disputes, the ones that are the most high stakes, the ones that will have the greatest impact on my clients, when I feel it's essential to run a guided choice process, I will look all over the country. I will interview mediators from all over the country to try to figure out who out there believes what I believe. In other words, that this process has a lot of value. There are certainly mediators out there which are known to have a little bit more of an academic bent, that tend to understand these guided choice dispute resolution principles, and you can find them if you look for them. But the theory and the strategy behind guided choice dispute resolution and the tactics that you use to implement it, they're really not new. It really is just a collection of techniques and practices of what, in my view, the best mediators have done for a long time. My mentor, Paul Lurie, is certainly Guided Choice's principal ambassador, but he certainly did not invent guided choice dispute resolution. I think we give him short shrift to say that he didn't do anything more than branding guided choice, because he's certainly been out there telling the world about it for the last 10, 15 years. But this is certainly not new. It's just a new way of thinking about dispute resolution and a new way of introducing those best practices that are used by the best mediators to a broader audience. So if you are somebody who is involved in a design or construction dispute and you're interested in achieving early, cost-efficient dispute resolution that does not require you to go through years of inconvenience and potentially unnecessary expense on the way to prepare for a trial or a binding arbitration hearing that statistics suggest is not likely to occur due to the prevalence of these cases settling on the proverbial courthouse steps, learning a little bit more about guided choice dispute resolution may be right for you.